asked for one of the Indian patent filed by a company called ICI, Imperial Chemical Industry, and it relates to a paint composition. And what happened, the controller heard the matter, and eventually he granted the license, compulsory license. And what happened, the patentee, we have been representing the patent at that time, because of some technical flaw, procedural flaw, we went for an appeal to the High Court and got a stay. And eventually, the stay was vacated on the last day of the term of the patent. So literally, the compulsory license was probably enjoyed by the licensee for a few hours. And so it was in statute, it's an old provision, but how far it become effective and it has been utilized, the things. And then also the other, the license, I have advised on the NATCO versus Bayer case. So my topic could be just to throw some practical tips for the license seeker as well as for the patentee, and how to take it down, because we heard about the provisions of law, we heard about the TRIPS, DOGA declaration, and other things. But if you wanted to obtain a license, or you wanted to defend granting of a license, what are the precautions you might be able to take it? That's what I just wanted to touch upon. Some of the thoughts I would like to share with you with a very limited time. No, we can talk about it for days and days, but short of time. Anyhow, we need to go with 84.1 section. And here it is, 3 years from the date of grant. So imagine that my earlier experience. Nowadays, it takes about 10 years to get a grant. And you ought to wait for another 3 years, even before you initiate your licensing. So then it might take probably a year or two. So even if you get a license, what could be the effective term of enjoying your license? Therefore, the criticality is that early grant of a patent is so much important. On the other hand, if you get a patent in 5 years' time, you wait for 3 years, thereafter you apply for a license, there's a possibility that you could enjoy the license for a term of 10 years. But if it is anything 3 years or less than 3 years, it's not worth. And because I have involved in a lot of pharmaceutical companies, so this is one of the things, the 3 years waiting period. But it ought to be there, because we have to give time for the patentee to explore and exploit commercial working of the patent. The burden is cost on him, and then that is the basis on which he has obtained the patent. And then the second aspect is that a person interested ought to apply it. And then we know that the license seeker ought to be an interested party, because the patentee can challenge that you are not an interested party. There's a possibility they can challenge it. The challenges were made in other provisions in the Indian Patent Act. For example, we say that we have a pre-grant opposition where there is no interested party. Anybody can file a pre-grant. Or on the other hand, if there's a post-grant or a revocation, the party will have to be an interested party, and they have to show the interest, why they have to get the license here. And then if they don't get it, how their interest would be affected. In case of probably the pre and post grant, if a bad patent is granted, their business would be affected, because they may not be able to carry on their business, or they may not be able to launch a new product, and many other things. But in case of a compulsory license, what is the interest a person can show? The interest that I'm going to launch a new product, and the interest ought to be much more loaded towards a public interest. So in other words, of course, there is a private interest. Every company ought to survive. they ought to be responsible to the shareholders and the board of directors. We are not expecting anybody to do charity. They're not here to do charity. But the interest is that the interest will have to be little loaded towards a public interest rather than a private interest. And then that is what the thing. In other words, that if the drugs are not available the reasonable requirements are not met, and it's not a reasonably affordable price, and it's not worked. And see, it's all loaded with a public interest. Of course, accompanied with collateral interest is a private interest. So that is what, whenever you try to seek a license, you need to project the public interest little more than your private interest. And here, the reasonably affordable price. Of course, we heard much about the affordable price. The affordability, if I take that under the Indian context, what would be the affordable price for a particular drug? If you say that if a drug is made available even for 10 rupees a day, I feel that much of the population may not be able to even afford that. So the affordability is not measured in terms of what is affordable to a population or a public, the things. It is affordable in terms of comparison. Of course, the moderator touched upon what could be the affordability and things like that. I'm touching upon a slightly different context. The affordability is a comparison. That means the drug supplied by the innovator company is amount X, or the similar kind of products are available at a cost of Y. And now I am making a product which is much more lesser cost, and also I'm able to cater the needs. And therefore, I'm making it affordable. And it is not affordable in terms of the gross income and etc. And then it's just not possible to sell a particular drug for an affordable cost, which is probably a poor general public could afford to do that. It ought to be affordable because it is accessible, available, and which is these guys will be able to manufacture at a cost without incurring any loss. And they are not expected that they have to come and dump money here and do charity here. It's not. They need to survive. So the affordability is a comparison that it is affordable, according to me, probably about 10,000 rupees a month, because it involves X, Y, Z, and so many other costs involved in that. So this is all the things. And a license seeker will have to take that in mind. And then also, if we're going to defend a grant of a license, we have to keep that in mind. The other aspect is that, I have some more time, another 5 minutes. Yeah. So I will go quickly. So all efforts will be made to seek and obtain volunteer license. See, compulsory license, it's like a forced license. It is from an unwilling seller to a willing buyer. And it's a contract between these two. So in this tug of war, in this negotiation contract, and all efforts ought to be made to obtain the first step, a volunteer license. So that means we have to negotiate, talk, and then upfront go with all the best terms and try to seek a volunteer license. Because those are the terms and conditions will be also discussed and adjudicated when you go for a compulsory license from the controller. And so that is what the things, such as like a request to seek a license should be comprehensive and complete, and the license seeker ought to establish a prima facie case. A complete and foolproof case we have, because you may not get a second chance. So go with the terms and conditions of license, and then like even the cost. So I'm going to sell a product for a particular cost. You ought to disclose that. to the patentee when you make an offer, and make it a comprehensive and complete. Don't go bit by bit. Then you will negotiate. What will happen? You delay, and you create a sort of relay that you offer something which is not complete. Then they will come out and say that you give me the details for certain other things. You try to respond. So the negotiation will take long time, and as a result, there will be delay, because we don't have patent term extension here. So that's the reason that we have to go and establish a strong case upfront. And the second thing is the information sought by the patentee to provided by the applicant. This information can involve even a trade secret. That is a little bit of the thing which we need to consider that. So, because when you offer that I'm going to manufacture a particular product, the licensee, the patentee have got a right to come and ask you, please, do you have a capacity to manufacture? And then you are able to meet all other regulatory demands and requirements. And invariably, whenever you try to seek a license, a compulsory license, there will be always infringement suit lying on you, because you ought to know, you are preparing it, you prepare yourself. You ought to invoke the Bolar provision before that. So this is the preparatory work. You have to do that before even we launch a request for compulsory license. The advantage is that the license seeker has got the advantage, he got the time. He can file a request today, he can make a request after 3 months, but you need to prepare it. That luxury is with the applicant, may not be with the patentee to defend the case. So this is what we need to do that, and we need to see that any trade secrets involved, it's a risk. You need to disclose that, and it could be used against you in some other proceedings. For example, if there is already infringement infringements against you, then people could use, the patentee could use that information in the infringement proceedings as well. So that risk, you have to take it. And so that is, and at the same time, the patentee also will have to disclose if there's an adjudication before the controller. He ought to disclose where are how much he has spent to come out with the drug, what are his costs for the clinical trials, and then what are the institutions he has employed or engaged to conduct the research, and what are the efficacy levels. A lot of information, he ought to disclose it. And some of them might be a trade secret, he ought to disclose that in order to defend his case. So this risk, they have to take that. The other one is that the information you provide will have to be authentic. It ought to be correct. You don't take it, no, I want to throw certain information and then throw some data. You need to establish it. In the same thing, the earlier matter where NATCO was by a case, the buyer was telling that, no, we spent about $2.5 billion to come out with this molecule, whereas they're trying to give only about $400 million, $2.5 billion. They say that we spent it, but they were able to give details for something like about $450 million. So where the controller was asking, what can I do? You're not honest in disclosing everything. Doesn't matter, even if it's $400 million, it's a huge amount. You disclose that one because we spent that money. And so that is what the issue is there. So you need to give information correctly, and you need to substantiate that at the time of adjudication. And then the patentee, in opposing the request, should justify meeting requirements directly, indirectly, including even the future plan. So when I say that reasonable requirements of the public are met as a patentee, and I'm doing that in a reasonably affordable cost or a price, I should be able to defend myself clearly. And that's the most important. And